A pension sharing order is an order that the court can make as part of a financial settlement that can divide a pension into two, so that a previously non-pension holding spouse has a separate pension in their sole name. They can choose whether they want to externally transfer that pension to a separate pension scheme of their own choosing, or whether they want to retain it as an internal transfer within the existing pension scheme. But in any event, it allows them to have the ability to make the key decisions in relation to that pension. It means that they can choose when they want to draw down and access that pension, and it ensures that they have protection of income in the event of the original pension holder's death. This is a departure from the previous arrangement, pension attachment orders, which are still used in certain cases where a pension scheme does not allow for a pension sharing order. So under a pension attachment order, the pension continues to be paid to the person originally holding the pension scheme, but it means that a percentage of that person's income, once received, is then paid to the former spouse, essentially by way of a form of maintenance. The risk to this kind of situation is that in the event that the original pension holder should pass away, this will then compromise the recipient's entitlement to continue to receive a form of income during their retirement, and therefore it is ideally a better situation if the ex-spouse can have a separate pension sharing order that allows for them to have that separate pension scheme, whereby they can then determine how and when they want to access that. As to what would provide for an appropriate division of a pension, consideration will normally need to be given to the parties' needs, contributions, health, ages, the length of their marriage. In certain cases, parties may have acquired pension prior to the marriage and may seek for this to be excluded from the pension share. However, generally the courts will presume that this should be included if the needs of the parties cannot be sufficiently met from what is in the matrimonial pot alone. This is where it's really helpful to have legal advice and potentially also financial advice from some form of pension on divorce expert or financial actuary. You can have shadow experts that will advise a client alongside a solicitor, or you can have a single joint expert who is instructed on behalf of both parties to be able to give guidance and advice on what an appropriate division should be. There are a number of different types of pensions, but the two key different pensions for the purpose of calculating the division of pension as part of a pension sharing order are defined benefit schemes and defined contribution schemes. A defined benefit pension is essentially a promise from an employer to pay a certain amount on retirement. It's usually directly linked to the final salary of the pension holding party, and therefore it's really important that if we have a defined benefit pension scheme in a divorce settlement, that we consider whether expert advice is needed in order to clarify exactly how much this pension scheme is worth and what would be an appropriate division between the divorcing spouses. It's usually appropriate that expert advice is therefore sought if there is a public sector pension or military pension or a service pension, because these are likely to be defined benefit schemes. A defined contribution pension scheme provides a cash equivalent transfer valuation, which essentially is a pot of cash which is then invested and is reflective of how much the pension holder as the employee and their employer have paid into the pension throughout the course of the pension holder's employment, and how much that has then accrued as it's been invested. It is much easier to divide a defined contribution pension because it's the value of the cash transfer valuation can be taken as a given amount, whereas a defined benefit pension scheme often has additional benefits and income which needs to be clarified in order to fully understand what an appropriate division should be. Generally, the length of the marriage will have an impact on what would be an appropriate division, particularly in light of a short marriage. So a shorter marriage is likely to give rise to more of a presumption that consideration should be given to what parties have acquired prior to the marriage and relationship. Generally, periods of cohabitation prior to a marriage will be taken into account, but if there is only a short period of cohabitation and marriage, then it's more likely that consideration will be given to the fact that a pension has been acquired prior to a marriage and therefore should be ring-fenced. There is no definitive guide as to what constitutes a short marriage, but generally the court perceives a marriage of less than 5 years to be a short marriage. If a marriage is longer than that, then it's likely that more weight will be given to the fact that parties have needs that arise as a result of that marriage, insofar as they have a need for financial provision on retirement, and therefore a pension sharing order may well be appropriate. As to the parties' ages, this is relevant in that it affects whether consideration should be given to equalising capital or income in terms of pension. So what this means is that an older couple who are approaching retirement will want equality of income on retirement, whereas a younger couple will have more opportunity to build up further pension in their sole name and will want to invest their pension prior to retirement, and therefore it's more likely that an equalisation of pension capital is appropriate. If parties have a disparity in ages, then this is where often expert advice is helpful in order to resolve what an appropriate pension share would be. Often there are more than one type of assets, which means that there are often other assets such as property or non-pension capital that parties want to take into consideration as part of a financial settlement. So where pensions are concerned, the courts will generally want to see this as a separate class of asset to capital and any other immediately accessible pension, because a pension is a deferred asset. You only require the income or the benefit of that on retirement. But in principle, it is possible for parties to say, well, if you receive a large share of a certain asset, such as property, then this party should receive less of the pension. And whilst this is sometimes perceived as providing a fair outcome in the short term, it usually then provides different results in the longer term because of that pension asset being invested deferred interest. So in theory it is possible to offset pensions against another class of asset, but generally the presumption is that where possible, different classes of assets should be seen in isolation from each other. But again, this is something that we need to consider as part of the full financial disclosure process.